cameras are unnerving, right?
Yes.
It's not my best side.
I told you to sit over there.
Good evening, everyone. It's Suzanne Letso, CEO of Milestones Behavioral Services. Yet again, we're here to talk about your retirement and your child. And this time, you're not going to have to listen to me most of the time. It's our distinguished panelists who will be bringing you information from both a legal and a trust perspective. So I think we're going to start this evening with Joe Confessori from Washington Trust. Thank you. Hold on, I'm going to pass this down.
Good evening. My name's Joe Confessori. I am with the Washington Trust Company in our private clients group. And for those that have that are not familiar with the bank, we are a regional bank and trust company with about $6.5 billion in assets under management, serving families, estates, high net worth individuals. But I would say over the past 4 years ago, when I met Milestones and Suzanne and Roger Letso, and we understood the community, learned about the community that they serve, and learned about them individually and the families. We wanted to put together this content that you have today. So I wanted to thank everyone for joining us tonight to really discuss your retirement and your child. We have some great panelists tonight. We're going to have a nice conversation just discussing topics around a special needs trust and estate planning. So tonight who we have with us is Lauren Drury. She's a Chief Fiduciary Officer at Washington Trust. She'll focus on really discussing the use of a trusteed IRA and using that in conjunction with a supplemental special needs trust. So Lauren, along with Greta Solomon. Greta, thanks for joining us tonight. She's attorney at Cohen and Wolf, and she'll focus on how do you integrate that within an estate plan. So thank you guys for joining us, and hope you enjoy the program.
So I'm here today to talk about trusteed IRAs. Has anyone heard of a trusteed IRA or used that in a plan? Oh, good, because that's more hands than I usually see, so that's good. So for those of us that don't know, a trusteed IRA is very similar to a traditional IRA, but it has a couple caveats to it. So your traditional IRA is where you're putting assets pre-tax into your IRA, and then you're taking distributions mandatory after 70 and a half, at your whim after 59 and a half. And you have your beneficiary designations on those where you can name, we have more guests joining us, where you can name, your beneficiary of your spouse or your children, and if they were to predecease, possibly going down generations. A trusteed IRA is a little bit different than that because your beneficiary designations can be used to craft more language than to just your children. You can put language in there where it says, leave the funds to my spouse, however, only hand out mandatory distributions, and then draft some trust language in there to make sure that there's some trustee control over the distributions that go out. Where that fits in with supplemental needs trust planning is in those designations. You're able to say things like, leave a share to my first child and let them have that piece outright. To my second child, if they're living, move that asset into their trust. If they're not, then just transfer it directly to my first child. That's really helpful because then if there's no other assets in that trust, when the IRA is terminating, you're not triggering the trust to go through a whole administration if the child's already predeceased. So that's really helpful with the supplemental planning side. The other piece I wanted to touch on, did you?
Yeah, I have a question. So if I'm understanding this correctly, and while I hear a lot of presentations, and we've done a lot of presentations about trusts, this vehicle is, I've never heard about this until you guys talked to me about it, and I'm having a little bit of a hard time right now. So, because I think it's really a unique tool. So if I'm understanding this, you're saying child number one is not the disabled child. Child number two is the disabled child.
Correct.
So in the typical situation where we've put money in a trust, depending upon other things, we might lose that money to the state. This would protect that. Is that what I'm understanding?
So it's a two-step answer there. Do you want to take it, Greta, or do you want me to run with it?
The benefits of a trustee IRA is the flexibility of the asset when death occurs, because you stay within that trust itself, and then the trust dictates what happens, and you sort of do your designation of beneficiary through the trust. And it's a seamless transfer, so if Washington Trust is the trustee of the IRA, they would continue to process everything, and it makes for an easier transition when you want to do trust for either typical children who are too young to get the assets, or you want to create an environment for a supplemental needs trust for a child with disabilities. So it becomes very handy in that regard. How it works will depend on the relationship you have with the fiduciary of the trustee IRA and how flexible that fiduciary will be within the document itself. So some fiduciaries have documents that cannot be changed. They're a set document, and you have to work within their rigidity. But Lauren has told me that their bank is much more flexible, and you can make changes. So there are lots of different options, which I'll go into in a little bit. But I think that from the start, the bank is a trustee of this IRA, not just the custodian. And it may not appear to be much difference for the average lay person who has an IRA. The difference really is in the transitioning and the ease of administration when there needs to be a transfer from the owner of the IRA to a beneficiary at death.
I have the special mic.
Sorry.
That's okay. I don't know what happened with the double feedback. And actually, that's a really good point. So, there is the big difference is the flexibility in the beneficiary designations. But another big difference during lifetime, which I probably should have touched on in the beginning, is you have your IRA. You're using it as you usually would. You're putting in additions. There are investments. When the time comes, you're taking out money. With a trustee IRA, where Washington Trust is trustee, or another institution if they also offer trustee IRAs, they can actually act in you the owner's incapacity. So if you were in a situation where you had the IRA and for some reason you didn't have a spouse in place or someone with a power of attorney who could act for you, Washington Trust as trustee of your IRA, if you were incapacitated, can still use your IRA as you might have been using it for your nursing home payments or to supplement income for management of your household or handling whatever else you were using those funds for. So actually, for trustee IRA assets can substitute where a power of attorney or a guardian would fit in. That's really helpful, especially if you usually have a power of attorney that could step in and help with your IRA and your incapacity. But if everyone in your document for some reason has predeceased or also is incompetent, and we see this a little bit with elderly spouses, that's really where Washington Trust as trustee can help make sure that your administration is in place.
And that works really well also because they'll also invest the assets for you. So for many people who want to direct their own investments, that's great. But when that owner of the IRA can't do that anymore because of cognitive issues or age or lack of interest, the bank can step in and become, as trustee, the investment advisor of the account. And as just an aside, having the bank act and then not needing a power of attorney is really good, because often the banks give us a really hard time when we try to act as agent under a power of attorney and direct either the investments of the IRA or the distribution of the IRA funds. This is a great way to avoid that problem.
Mm-hmm. And if the power of attorney for some reason has lapsed or can't be used, the IRA can be administered while a guardianship or something else is being put in place, which can be really timely. So it really is a seamless tool when you're dealing with incapacity on ownership. And I think it's worth noting as well, when you are working with your estate planning attorney and you are drafting your power of attorney, what we like to see as an institution and institutions that will accept powers of attorney that are not on their form is direct references to qualified retirement assets. That's really what we're looking for a power of attorney.
And because we know that. In 2017, when Connecticut revised its Power of Attorney Act, they added in a provision called retirement plans, which within the statute does exactly what the banks need to have. So we've made it a little bit easier, but it's still not as easy as it could be.
Can I ask another question? Just as point of clarity then. So I think if I were trying to say what's the difference between this than the usual trust that we talk about, is that usually we're just talking about a planning document for the person that we're responsible for. This one is a much broader umbrella that can cover us, our kids, both with and without disabilities, or anybody else who want to add, right?
So what this is doing is it looks just like your traditional IRA that you're investing your assets in, but your trustee on it can handle it in your incapacity. When you pass away and you utilize the beneficiary designations of a trustee IRA, that's really where the rubber hits the road. That's where it really becomes really different, where you can draft into your beneficiary designations that the funds for my child who does not have a disability, those funds, they should only get the mandatory distributions each year, and the remainder that's in there, say, should only be used for their education or the purchase of their first home, using an example. Then anything left should then supplement my disabled child's supplemental needs trust. So you can really draft in a lot more flexibility in your plan. It's almost like having a mini trust within the beneficiary designations if you choose to use it that way. You don't have to, but you can. As far as asset protection and eligibility for governmental aid, all of that still lies the same within the documentation within your supplemental needs trust, which you can take the whole trust and drop it into the beneficiary designation, or like Greta and I were discussing earlier, really, if you have that drafted on the outside, it can just be referenced that the designation says to my child's special needs trust dated this, or if my child is living to that trust, if they're not living, do this with it instead. I don't know if you want
The really key piece here is the flexibility that you need to have when you have a child with disabilities, and we have an unknown, which is the variable of what will the state be doing, what benefits will be available, what will my child need, because often the child's ability to be independent is not necessarily known when you do your estate plan because the child's still young. If you live to a normal life expectancy, then we should be able to plan perfectly for your child because your child will be an adult and we will know the extent of abilities, but often we're not planning that way. So to have flexibility in the plan is really, really important, and the trustee IRA can give you additional flexibility.
Joe, I think you had a question as well.
Lauren or Greta, what should be the what are the tax implications for the beneficiaries? If obviously you do all this work, you set up a plan, you try to think of anything that can happen so those assets are protected, and you don't really want Uncle Sam to get the benefit. So what are the tax implications? Could you comment on that?
You want me to do
You are a tax attorney, right?
Yes, I am. Oh, well, it goes to me. So let's talk about before the law may change, because there is a pending legislation in front of the Senate and the House, and God knows if they'll be able to pass it or not. But under the current law, there are very strict rules about how we pay out IRA proceeds. And if you want to take advantage of paying it out over the longest possible time to a beneficiary other than a spouse, you have to follow the rules, which require something called a designated beneficiary. A supplemental needs trust can be a designated beneficiary, and if you do it properly, you can then defer payout over the life expectancy of the special needs child. And the minimum distribution you make each year can stay in the supplemental needs trust. It doesn't have to go out directly to the child. And if the child's young, you could be talking 40, 50, 60 years of a payout, which will allow it to grow tax-free. Every dollar that comes out of the IRA to either the child or the special needs trust is subject to income tax, both on a federal level and a state of Connecticut level under current law. If you screw up, then at death, you were going to have a much shorter ability to defer payout, which means you can't stay within that shelter of the IRA. The pending legislation limits the deferred payout to 10 years. So if you have someone who is more than 10 years younger than the deceased owner of the IRA, the best you can pay it out is over 10 years. I have not seen the legislation. I expect that it will simplify how you can take advantage of it because it's not a very long deferral payout. I do know they are also increasing the age where you're required to take money out if you're an owner or a spouse on a rollover, and that would be not 70 and a half, but age 72, and make it a little bit easier. So watch the news and see if they do adopt this retirement plan changes. I don't know the name of the legislation.
I have it.
But Lauren's got it.
But
But it does change our planning, to be honest with you, and probably makes us go back and review everything we've done for beneficiaries of IRAs, whether they be adult children with disabilities, minor children with or without disabilities, or spouses, and watch the space, I guess they say.
Yeah. And
Can you clarify what you just said about the period over which the payment?
Just repeat it, sorry.
I'm sorry. Thank you. Can you please clarify what you were saying about the period over which the payment could be made? At one point, it seemed like you were saying the Supplemental Needs Trust could qualify as a designated beneficiary, and the payment could be made over the life of the beneficiary, of the child. And then later on, you said that there was a limit of 10 years. Could you clarify that? Thank you.
Under current law, under the rules, if you have done it properly, and there's a way to do it, which I could take 2 hours to explain it and still not be clear, so I'm not going to do that today, but if you do it properly, the child who's the beneficiary of the Supplemental Needs Trust is the measuring life for how long you can pay it out over life expectancy, under the current law. Under the new legislation that's pending in front of Congress, the most you can defer payout is 10 years. So let's say you have a child who's 20 years old and life expectancy is 60 years. When the parent dies, if the child's 20 years old and you've done everything properly, the IRA can stay in place for 60 years, and every year you take a certain amount out. The first year it's 1/60th, the second year it's 1/59th, etc. Under the current law, the most you can defer, under the new law that's proposed, if it's passed, the most you can defer is 10 years. So the first year you have to take out 10%, the next year you have to take out 1/9, and after 10 years you will be fully distributed, which accelerates the amount of income tax that you pay, and it also limits the amount you can grow tax-free. It's not something we want. It's been talked about for a long time because in the need to raise funds to pay the bills, they need to raise taxes, but they don't want to raise tax rates. So this is a way of raising taxes without the average person really understanding that it's an increase in a rate. I don't know if it'll pass. It seems to me that it is a popular bill, and it might pass. So that's why I say watch the space. Just keep your eye on the statute and the news.
If we could get what that bill and bill number is, we'll put it on our Facebook page, because those of us who are concerned about it may want to be talking to our Congress people to say, we like this part, we don't like this part, and see if we can't get that changed.
And it's worth noting, so it's called the Secure Act, but there is, the current version out there does have exceptions for surviving spouses, children under 18, and disabled individuals. So there might be some flexibility in there if you take a look at it.
But there's an exception for trust ownership.
Yeah.
Can you repeat the question?
The question was, do you want to do?
Yeah, so it's kind of a weird part of the law for our population because there is an exception to the 10-year rule for people with disabilities, but there's not an exception if a trust owns the IRA. So ordinarily we would leave it to the special needs trust. Yes, the kid has a disability, but no, it's a trust, so therefore it's over 10 years. And with the accelerated tax rates of trust, that can be very dangerous for what we've been put together. To
further complicate matters, If you pay it directly to the disabled child, it would come under the rules of conservatorship and be more possibly overlooked by the probate courts, and therefore subject to a bunch of rules. And when the child dies, it would be subject to pay back to the state of Connecticut for whatever benefits that child has received. So we're in a very awkward situation of having to balance money and the cost of money and the ability to leave money deferred for many years versus losing the funds to the state and not being able to eventually transfer the funds to other family members. It's not an easy thing to even start to think about, and I dread it, but it may be something we have to face sooner than later.
So if we don't have any more questions about the Secure Act, I do want to circle back to something you had mentioned, Greta. That's, which is, you've mentioned a couple times that it's really important to make sure that the trust is drafted correctly. And I can't emphasize that enough from coming from our standpoint where we administer IRAs and trustee IRAs all the time, that not only should you, and if you're an attorney in the room and your clients, you should be counseling them to double check their beneficiary designations often to make sure they reflect their estate plan the way it's supposed to be, and double check with your clients and with your attorneys that if you've named your trust as a beneficiary, that trust is drafted to hold qualified retirement assets. Because people come in all the time and just name their trust, and that trust isn't meant to hold those assets. So I can't put that warning out there enough.
So that's a good segue into the next question. Can a trustee IRA hold any kind of asset? Or is it limited in any way?
So from our perspective at Washington Trust, we can hold most assets. We generally don't hold partnerships, but that's always up to debate, and we can usually work with a client on that. But as far as your standard investment opportunities, our IRAs can hold them, but that varies from institution.
Can you hold real estate?
I don't want to answer that fully. My understanding is we do not. I don't know about other institutions. So, thanks for tripping me up.
Hi, ladies. I just have a question for maybe those folks that are in the room confused about why would I use a trustee IRA versus I've already set up a special needs trust. Do I change the language there, or in what situation would you use the trustee IRA? Maybe you can talk a little bit about that. For those people maybe that have a lot of retirement monies versus those that have a lot of assets other than retirement money. So maybe talk a little bit about that.
Mm-hmm. So where the trustee can become very powerful is where the majority of an individual assets are within their IRA or other qualified retirement accounts that are rolled into an IRA. If a client has a lot of assets elsewhere and it's not all concentrated in their retirement account, chances are they have a full estate plan that's been drafted to deal with those assets. Sometimes clients have almost all of their assets in their IRA and then will just only need the supplemental needs trust for their disabled child. So that's where, there's great features where you can manage an incapacity and other issues, but if there's not a reason for a full-blown estate plan, which most of the time there is, but if there's not, you can use those designations to really craft to the family that can get the assets outright or with just slight limitations, and then move the rest of the assets into the supplemental needs trust. And it's worth knowing if you're working with any institution that has the trustee IRA and is using the beneficiary designations where they're going to be acting as trustee upon your passing, you want to make sure that that language in there protects your family the way they want to. And I'm referring specifically that when we do that language, we try to draft in provisions where if the next generation of beneficiaries doesn't want to be with our institution, that they're able to change that to another institution. And if you're, working with a different IRA offer, you want to make sure you can get that language in there. You want to make sure that you're giving your family the protection and flexibility they need.
The other reason is often families who have children with disabilities have a need to pick a trustee, and they have reluctance often to put that burden on other family members. Or the child's going to live a long time, and the people they pick as trustees just don't have that same length of life. And having an institution act as trustee solves that problem in many ways, as long as there's flexibility to move it around if you're not happy with the results of the institutional trustee. Having a trustee IRA, especially in those cases where it's the major asset of the family, and often that's the case, allows you to have that in place, have that ease of transition so there's not a disruption in the investments when death occurs, and allows you a lot of flexibility in the planning as long as you coordinate planning. And there will be always other assets outside of the IRA, like a house, etc. And you can always utilize that same institutional trustee for the other assets if planned properly. And it's just a question of picking the right professional to do your planning and making sure the team talks to each other. Because if you can't communicate, whether it's on a medical basis or a financial basis, you don't get the best service that you really need to have. So it's really important for whatever attorney you pick to interface with your financial advisor if that financial advisor is going to be involved in the fiduciary aspects, i.e. being a trustee.
I think it's for kind of clarity, because I think we're all getting a little, sometimes we get a little confused because there's different kinds of trust and trust ID. Can we think of the trustee IRA as kind of a will substitute within an IRA? Because when we have our wills, we can be very specific as to where things go and what happens if someone dies before someone else or not. In an IRA, you usually can't. There's just two beneficiary lines. This basically turns the beneficiary lines of an IRA into kind of a will substitute for those assets being flexible. But ultimately, for the funds going to our special needs child, their portion's going to go into their special needs trust afterwards. But then you may want to consider a corporate trustee after. Did I get that right?
I think you did. I think that's a nice way to put it.
Yeah.
Lauren, can you comment on cost?
The question was cost. I can't speak to other institutions, but I can speak to ours. Oops, that's right, I had the wrong microphone. So in case anybody out there didn't hear me, the question was as to cost. I can't speak for other institutions. In our institution, the cost of an IRA versus a trustee IRA is identical during the owner's life. So in ours, it starts at 1% and goes down based on tier of assets. Where the fee goes up a little bit is once someone dies or there's an incapacity and we have to start really using our fiduciary duties and carrying out, as trustee, then that fee goes up slightly by 20 basis points for us. So it's not a big fee difference, and especially, where during lifetime, the fee's no different.
And just to point out the fact that when death occurs, whatever you do, you're going to need a financial advisor who's going to charge. So you might save a few pennies here and there, or a few dollars here and there, but you're still, if you're an appropriate individual trustee, unless you are very knowledgeable in the area of investments, you will be obligated under the law to hire somebody who's a financial advisor, because otherwise you'll be failing to do your fiduciary responsibilities. So if it's your own IRA, nobody cares what you do with it, it's your own money. But once you step in to handle other people's money as what we call a fiduciary, who's a trustee or an executor, you are obligated under the law to seek the advice of people who are professionals in this area. And I can tell you, those of us who are not financial advisors are not professional in this area, even if you like to think you are. And therefore, we would always advise you to hire professionals to invest the assets, so the differential cost is not that extensive.
Do you have anything additional?
Well, I think we can't say enough how important it is to coordinate your estate plan. There are assets that are considered probate assets, which are assets in your own name that when you die would go according to your will. There are assets that are not probate assets. Those are assets that will pass by a different vehicle, either because you named a beneficiary as an IRA, you've got it contained within a trust document, whether it be a trustee to IRA or a living revocable trust, or it's insurance that you designate to an individual, or you own the asset joint with right of survivorship with someone else. It's important for the planner to know everything you have, so when you say, I want half my assets to go to one child and half to go to the trust for the disabled child, we know what half and half is. We know how to calculate it. And even if it's owned in a special way, we can always, within the will or within a trust document that's a will substitute, we can always calculate it so we take into account everything that there is. The lawyer who drafts your documents, and believe it or not, it should be a lawyer, not LegalZoom on the computer, needs to know everything about your financial life to do his or her job properly. And of course needs to know what your goals and your ideals are, what you want for your family after you die. When I meet with clients and we go over their family dynamic, we talk about who's the people in the family that they want to reward and those they don't want to reward, and what the goals are. And we don't talk about taxes, we don't talk about a trust or not a trust. I tell my client, just tell me what you want to do and I'll figure out how do you do it. But we need to know what you want. And so you can tell the professional in lay language what your goals are. You don't have to worry about which trust or whether to have this, that, or the other thing, because once the lawyer knows what your goals are, then the lawyer will start a dialogue with you and hopefully also your financial advisor. How do we best do this? How do we best meet the goals of the family or the individuals coming for estate planning? Coordination is the key. You can't just put a will together and not look at the assets, because I can tell my clients, if you own everything so it's going to pass outside the will, you can have the best will in the world and it's not going to make any difference. Because when you die, it's not going to go according to the will. The will's going to be in a drawer somewhere, and it's going to go according to whether you owned a joint with your child because you wanted your child to manage your money till you died, but then all of a sudden the child is supposed to give it up and give it back to the estate. Well, that doesn't usually happen. Or you're going to have insurance payable to somebody you named, and oh, wait a minute, that's my disabled child, but I forgot to change the beneficiary designation. It still has my child named. I often meet with clients who don't have supplemental needs trust or special needs trust, and we do all the planning, and then I say, okay, go back to your insurance company, go back to your employer, make sure all the designation of beneficiaries are correct now, and we change them, and lo and behold, death occurs, and either they weren't changed, or they changed them and then they moved jobs, and when they redid their designation of beneficiaries, they forgot, and they didn't remember to do what they needed to do. So again, coordination is the absolute key here if you want to protect your assets and make sure that your child has use of those assets for their lives and still can access benefits, can still get into those programs they need to get into, can still qualify for subsidized housing, can still qualify for waiver programs, can get services that are very costly at a reduced price. Because sometimes you can be on Medicaid, and when you have to get something, you pay the Medicaid rate. Well, even if you have to add something to the mix, the rate is still cheaper than if you went out and did it privately. So if you come out with anything today, coordination is the key. Working as a team with your advisors is a key. You just can't do it on your own, and you can't hold information out because you're afraid to tell this person or that person. You don't want people to know. Well, if people don't know, they can't help you.
And I was just, I think we're getting close to parting comments, but I think also we have a couple more questions.
So one of the questions we had received was, will a trustee IRA affect my special needs child's qualifications for state or federal assistance after I pass?
I think you've commented.
And of course, that depends on what the trust says, and I've talked to Lauren about that, and the trust for the disabled child that's created after death of the IRA holder has to have the right language in it to protect the benefits of the child. But it's very possible to protect the benefits of the child if it's done properly.
Yeah. You just want to be sure that you're working with your estate planner to make sure that you achieve that.
Can I have a family member be with the, as a trustee on the trustee IRA along with the bank?
That has never come up. My inclination is no. And that's only because it has to be someone that's able to control and custody the IRA since it's held within the IRA itself. But that's not to say that you couldn't have the designation where it's going out from your trustee IRA to your supplemental needs trust. And then if you had a corporate trustee working with a family member in there, that makes complete sense. We love to have family members as co-trustees because you get the personal touch on the relationship, you understand the history of what's going on. These are usually the people that have the guardianship or they're working with you to coordinate with medical providers. So that's really where your individual co-trustee serving with a corporate trustee is really helpful.
In some states, not yet in Connecticut, but hopefully soon, there's a concept of a directed trustee. So in states that have this statute, you can have two trustees and you can allocate to one trustee a set of duties and you can allocate to the other trust another set of duties. In that case, it works really well. If you have a corporate fiduciary, you can allocate to the corporate fiduciary the investment of the funds and allocate to the individual fiduciary the decision of when to make distribution and how to make distribution. Because often clients don't like using institutional trustees because they feel that if they need an extra distribution, they have to go through a committee and it's an awkward process. But if you can direct the job of each trustee, you avoid that problem, and it works really well. We're hoping in Connecticut to get a statute soon that would allow for directed trusteeships. We don't have it right now.
I have another question. So you guys are in Rhode Island, you're here in Connecticut. We, on the Facebook Live, have had somewhere probably between 1,000 and 3,000 people watching our events. I don't know how many we'll get tonight, but they may not all be from either Rhode Island or Connecticut. What other areas, are there any limitations to where you can provide these?
So for the trustee IRA, no, we can provide those across lines based on residency. For acting as trustee, we have trust powers in several states outside of Connecticut and Rhode Island. I know we have Mass, we have New York on a case-by-case basis, we have Missouri, because we do. We had a client that needed us there. So if it's an out-of-state client that wishes to work with Washington Trust as trustee on something, we don't have the powers in those states, we'll go out and seek them. And that's not that we have to have 3 clients that are asking, it's if one client asks, and that's kind of how we handle it. So we are across several states.
And just so you know, in Connecticut, there is a process if you want to use not Washington Trust, because obviously they're in Connecticut, but if you wanted to use a bank that was not licensed in Connecticut for some reason, there's a process where you can ask the Secretary of State to approve them to serve as fiduciaries. So there are, I'm sure other states might have similar laws, so you might be able to accommodate those kinds of situations.
Yeah. And the comment I was going to make earlier, and I think it's a good one when we were talking about distributions and corporate trusteeism as a whole, is when you're drafting your estate plan and you're picking a corporate trustee, because that's what makes sense for your family, try to meet with that trustee before you pick them. Get to know what their process is. Get to know, if I have an emergency, how fast can I get money out of this trust? What's your decision-making process? What's the ease of administration? Where are the hiccups? Can I meet the person or people that would be working on my account? And once you get comfortable with an institution, make sure that they meet your disabled child and get to know them as well. I mean, that's what we do. We go and we sit at their kitchen table and we eat brownies and we talk about their plan and we get to know their needs. So you want to make sure that you're really comfortable with your corporate trustee, because that's who your family's going to be with your passing. So
I like the brownie idea myself.
we have a lack of brownies.
The other thing to know is that if you're drafting the trust through your own attorneys, you could easily put in a provision to give an individual the right to remove and replace a corporate fiduciary if you're not happy with the results. In some places, that's called a trust protector. It could also just be a family member who has that specific power. Originally, when this was thought out many, many years ago, the corporate fiduciaries didn't like that added piece. They love it now because that means more people will use corporate fiduciaries knowing they have an out if they need it.
I'm just feeling a little confused, so I'm wondering if you could give some examples of why you would want a trusteed IRA as well as a special needs trust. Like what benefits, are they primarily tax benefits so that you're not realizing all the tax on the IRA that's being inherited, even to keep it in there? Because I think you mentioned right now you can keep assets in there for say 40 years or 60 years if that's what was necessary, but does that shelter in the same way as a special needs trust does the IRA assets for the child that's disabled so that they're on their benefits programs and whatever? And what would be some examples of things you would want to pay out from an IRA, say, versus a special needs trust?
So with the special needs trust, the trusteed IRA is only moving assets into that trust, into the special needs trust. So this, the administration.
So that's the primary goal, or
So let's give them a fact pattern.
Okay.
So Mr. and Mrs. Stone have the bulk of their assets in retirement accounts because they both worked for corporations, and the bulk of their savings were there in their 401k plans. So they may have insurance that is payable to a trust they set up for their children, both typical and disabled. They may have a house or maybe a couple houses. And then they have these very large retirement accounts, and they've decided to retire. They have maybe their children are in their 20s, and they were late in life having their children, so they're now in their 60s. And they've decided they've accumulated enough funds, so they want to take it easy and they want to enjoy life, and their disabled child is in an independent living environment separate from them, and their typical child is out and about in the world and making a living or whatever. So let's say they have $3 million in retirement accounts, and they're going to roll everything over, and they meet Lauren and really love her, and so they're going to talk to Lauren about a rollover IRA, and they're going to both have separate IRAs because if you retire from a company and you want to take your 401k money, you have to roll it into an IRA that has your name on it. You can't give it to anybody else. And so they both each, let's say, $1.5 million IRAs. I'm going to make it equal. And they want to travel, and they don't want to worry about the investment of the IRAs. They don't want to worry about getting required minimum distributions. And they want the ease of life without having to worry about all of these rules that if they violate the rules, they're going to be in a lot of trouble. So they meet Lauren, and they decide they're going to use Washington Trust Company and set up 2 trusteed IRAs, one for the wife and one for the husband. And Lauren's going to tell you now how it works operationally while these people are still living.
Sure, I will happily do that. So while they're still living, you have your investments in there that are being managed by Washington Trust with your risk tolerances and making sure that they fit your timeline appropriately. As we mentioned before, if you happen to become incapacitated because it's a trusteed IRA and you're away, you're in another country, you can't get back, your power of attorney can't work, we can still administer that IRA for you. Then upon passing,
Well, don't forget though, while you're working with Washington Trust Company, you now have to do a beneficiary designation of this IRA, what happens to it when you die. And so we have 2 kids. We have a child who's perfectly fine, and has no children of his or her own, and has vowed never to have children, just to make life easier for us. And the family's decided that they're gonna split the assets 50-50. And they're gonna have an estate plan to cover their non-IRA assets, and they're gonna provide at death that the trustee IRA, half of it's gonna go to the child, but the child says, Mom, I'd rather do my life the way it is, and I don't wanna have to worry about required minimum distributions and the investment of assets. I really like Lauren too. Can we continue the trustee IRA for me? And what's the answer?
The answer is yes, of course we can, as long as you're a good client. The answer is yes. So we would maintain that relationship with that child and administer that trustee IRA for them as well.
So now we have your disabled child. And the family decided they would set up their own separate supplemental needs trust because they want to be a little more flexible and they want to provide for a second trustee because they want to make sure that there's somebody who knows the child and is aware of the child's needs, and if the child has changes, can reflect those changes better than a corporate trustee. But they still want Washington Trust Company to manage their assets. They happen to live in the state of New Hampshire, which has a directed trustee statute, because that's where they ended up, and you have the right to manage it because you've got corporate ability in New Hampshire. I don't know if you do or not. And so what happens is they set up a supplemental needs trust under New Hampshire law. They have two trustees, an individual who is going to be responsible for deciding what the needs of the child are and therefore direct when the monies get distributed. But Washington Trust is now going to be co-trustee of the supplemental needs trust, which is out of the trustee IRA. But it's going to be done in such a way that we can defer payment, if not for 60 years, maybe at least for 10 years. We're not going to fill into the exception because we want the money to stay in the trust. The trust will say that when the special needs trust child dies, that child's interest in the trust ends, and now the money after payment of certain bills and stuff will pass to the other child or go to charity or do whatever the family wants. And I think that's sort of how it should work in that kind of scenario, even though I'm being a little simplistic.
Yep, I think that's a good way to demonstrate it and break it down. I don't want to go into it here because we're focusing on special needs and supplemental needs trusts, but if you were dealing with a complex family situation where you were leaving your IRA to one child that maybe had spousal issues or threatened divorce, you can draft those beneficiary designations of a trustee IRA with some protections for her, and then still, leave the other share for the supplemental needs trust. So there is a power in those designations beyond what we're talking about today, and I'm happy to talk to anyone about that. But it really is, which I appreciate that example, kind of a way to do a mini will with your IRA assets.
And I want to tell you that there are a lot of reasons to have a trust, not just for a disabled child. And we don't want to overlook that, as Lauren said. And I can tell you how many parents come to me and say, I don't want my kid to have the money because I don't want them to have to split it with the future ex-spouse. They're not even married yet. And therefore, what can I do to protect? So that's another good example.
Yeah.
You got it?
I don't know if there are any other questions in the audience, but I have one more I can save if there are any others. Okay, any online? No? All right, so simple question. How early is too early to plan? So, yeah, if you're thinking about it, should you be doing it? I mean, that's the question, right?
Yep.
I
was going to. My answer is, if you're thinking about it, you should be. When they have children, but that doesn't necessarily need to be your trigger. Some people start thinking about planning when they have illness, but really you should be thinking about it from the outset. As soon as you have any kind of assets, or you're concerned about what your legacy is going to look like, or ease of administration on your family, those are all good times to start thinking about it.
When you have a child with special needs, you're doing your child and your family a disservice if you haven't started planning. Even if you don't have what you consider to be a lot of money, I don't need it, I don't have enough believe me, I do wills for people who have very little, but they do want to protect those assets, even if it's $30,000, so their child continues to get benefits. And there are lots of ways to do trusts, even for $30,000, not necessarily using a fiduciary such as Washington Trust, but there are other options in the state of Connecticut that you can even do a small trust for a child with disability.
And I am the cautionary tale. It's not enough just to do it. You have to do it with somebody who's really knowledgeable about this. My husband and I have done this 3 times, and I know we need to update, but that's beside the point. But we've done it 3 times because we went to somebody we believed was an expert who put something together that frankly wasn't worth the paper that it was on. So we went to another expert, laid, like you said, we should have brought the brownies, but we didn't. That's maybe where we went wrong. But we laid everything out and said, this is what we want, and this is what we have, and this is, what we think the future is going to be for our son. She put something together, and the 2 piles of documents were still not worth a brownie. And then we ended up with Greta, and we're very comfortable. And Greta's not obviously the only person that could do it, but having somebody who, we checked Greta's references, we did a lot of work the 3rd time because we spent a lot of money on attorneys that didn't help our family and just reduced the amount that we could leave for our son. So I think making sure you get the right partner is really important.
And while you're at it, please consider other family members. A lot of well-meaning family members leave money to children with disabilities, and they just make an outright bequest. And so when you're talking to an attorney to do your estate plan, don't forget to talk about Aunt Minnie, Uncle Jack, Grandma and Grandpa who want to do something for my child. I usually ask clients about that. A lot of attorneys don't necessarily ask the question. But if you're doing all this planning and you're doing all this protection, don't forget there are other people in your family who might care about your child, and it doesn't hurt to have conversations with family members.
So another way we screwed up is that we had that conversation, but we weren't specific enough. So I don't know if this happens in other families, but in my family, it was a tradition when a child was born, instead of giving a gift, you would buy a savings bond. And my father put savings bonds in his name, but with my son's social security number. So when we asked him, is there anything in Tyler's name because we can't have that, he said no. Well, we looked, to make a long story short, you remember this?
Oh, yeah.
Oh my gosh, it's really, we wasted so much money. So the state, we didn't even know that these things existed. We'd never seen them, we weren't holding them. But the state, after my son was in a group home for like 3 years, came back to us and were like, you have some money and it's ours. And we had to turn it all over to the state. It was terrible.
Yes, use a professional, use someone that does estate planning as their practice and that has a specialty in special needs planning. I cannot emphasize that enough. And I know from our standpoint, if we're named as corporate trustee in your special needs, supplemental needs trust, we take a look at that document. We make sure that it has everything that we need to administer a trust so that we understand the intent of it and so that it complies with all the different regulations. And if you send us something, it would never come from Greta because we would never come back to Greta and say, this plan is not working. But we would go back to your attorney and say, look, you've named us here, but this is what we're seeing. Can we talk about why this is drafted this way? And we do that whether or not we're named as trustee right away or as successor trustee, because we want to make sure that your plan is right from the get-go.
In that regard, I'm often asked to review trusts that were created outside of Connecticut, but the family has moved to Connecticut, and now the child with disabilities is accessing benefits in Connecticut. And Connecticut is probably one of the most strict states when it comes to using trusts as a reason to deny benefits. So we know what they need to look like, and often we are faced with an issue of how do we fix the problems. And there are ways to do that, but if you are moving out of Connecticut to another jurisdiction, you've already done the planning, just make sure your planning's reviewed for, not necessarily where you're going, but that would be a good idea, but also where your child's gonna end up. So we have clients also who have children in Connecticut who end up in Massachusetts or New York because the benefit programs are better there. And then they have Connecticut documents because they live in Connecticut, but we know that when the trust is created, it's gonna be used by either Massachusetts or New York. Connecticut's not gonna look at it because the child won't be in Connecticut. And we have relationships with Massachusetts Council, for example, where we'll run things by them if we know there's a possibility the child will be moving. I'm licensed in New York, as are some of my partners, so we sort of have a handle about New York. But it's an important consideration also to make, so when you're meeting with an attorney, if you're gonna be mobile or you think your child will be, make sure you speak to that as well.
So it seems like the common theme is plan early, plan periodically, right? Update the plan. We've touched on it a few
Absolutely.
times.
Every 5 years minimum. I don't know if
Yep.
you, yeah.
And then I'll tell you, the power of collaboration, we've all seen it work, you guys certainly, every day, when, there might be an attorney, very experienced, drafting these agreements after they listen to their client. They talk to a bank and trust company that has attorneys on staff, not practicing, but attorneys by trade on staff, along with others that are part of the team, right? So that power of collaboration really, really means a lot, and you end up with a better product, a better plan, and it's really invaluable. So if there are no other questions, I don't see any or hear any. Just wanted to thank Suzanne for hosting here at Milestones, so thank you. Greta and Lauren, thank you for
Thanks, Jeff.
for participating, and I hope all the families in the Milestones community have appreciated the time. We did offer to set up one-on-one sessions. I know there were a couple before the session started tonight here, but if you have follow-up questions, there's contact information on the invite, and you can reach out to anyone up here, and we'd be happy to continue the conversation and figure out a way to help. So,
Thank you.
with that, thank you.
Thank you guys for making the long drive.
Yeah.
That was pretty good.